The only thing worse than no information is bad information. And Freeman is good at giving bad information. I like the hair, buddy. So what Freeman is doing is he's playing a hearing. It is an oral argument in front of a federal court of appeals. It's the Ninth Circuit. And he makes some claims that are pretty hard to swallow. First of all, he says that the court is hard on the government. Well, the court should be hard on the government because the government doesn't have a very awesome position. The government is trying to claim things that are traditional public forums or should be considered traditional public forums. The government can restrict your right to film on them, and that's pretty ridiculous. But James seems to conveniently forget that the judges are also the government. The judges are government officials, government employees. They are representing the judiciary branch of the government, the third estate. So James is being silly there. The second thing that James thinks is that somehow because he is able to film, or because there is filming of appellate proceedings in the Ninth Circuit, that somehow we need to have people filming in courts because the Ninth Circuit does it in appeals courts of appeals, that somehow that means that we should have filming in all courts because somehow this is necessary and relevant information, and it is not relevant information. And it isn't all cases in the Ninth Circuit, James. There is a very limited selection of cases. Appellate courts may, under the current rules, film. And I believe there are 3 appellate courts. The 9th, the 3rd, and the 5th. Oh, the 2nd, the 3rd, and the 9th. They adopted rules and guidelines to allow camera coverage. But you'll notice that it is very specific camera coverage. You could see the attorneys making the arguments, and you could see the court. Now, there are also some actual district courts that you can see specific things on, but they are limited. They are limited in what you can see, and it is only for civil cases. And it is also only in the California Northern. It's in the Ninth Circuit only, and it's the California Northern, the Washington Western, and Guam. So, no, we still don't need cameras in courtrooms, especially not cameras being held by chowderheads who don't understand the reasons for the restrictions. James, you don't understand the reasons for the restrictions. And there is a world of difference between cameras that are controlled by the judiciary branch that can censor out things that need to be censored, and that will only film specific things in specific areas at specific times and won't catch bench conferences and things like that. And a camera being held by a chowderhead, a balding chowderhead with a enormous, disgusting beard. So there is a difference. There is a difference. But the other thing that James doesn't understand is that oral arguments, the judges are going to generally pick on both parties. That's normally what happens. This is a this is a case that the district court screwed up on, and the plaintiff, the appellant, has a much easier time of it. And because I'm not going to make you watch a video, we're going to read. We're going to read. This is the result of the not only the hearing, but of the documentary evidence and pleadings that were submitted in this case. Because the hearing is not even half of it. A lot of the fighting in a court is done at the pleading stages, at determining and making arguments in pleadings, at determining what evidence can, would, or should be allowed, in finding the evidence, in depositions, and all the other fun stuff. And at the appellate level, you don't have that. You just have the legal arguments. So both sides would have submitted briefs. Then you could make an oral argument to kind of hopefully cement the brief, or plug any holes in the brief that the judges may have discovered. Hopefully you can tap dance over them well enough that the judges will think that your brief wins. So we're going to skip the fluff, and we're going to go to the opinion. This is by Bybee, a circuit judge. This is, he's the judge who's writing the appeal. Plaintiffs Ray Askins and Christian Ramirez are advocates on border policy issues. In separate incidents, while on public property, they took photographs of activities at U.S. ports of entry on the United States-Mexico border. Both were stopped and searched by officers of the United States Customs and Border Protection, CBP, and their photos were destroyed. According to CBP, Askins and Ramirez were on CBP-controlled property when they took the photos. Under CBP's policies, members of the media must obtain advanced permission from CBP to photograph, videotape, or film inside or outside of port of entry buildings. Askins and Ramirez filed suit for violation of their First Amendment rights and sought injunctive and declaratory relief. The district court dismissed the plaintiffs' claims, applying strict scrutiny. Strict scrutiny would be good for the plaintiffs, normally, and upholding. But the court applied strict scrutiny, and they still ended up upholding CBP's policies as the least restrictive means of serving the compelling interest of protecting the United States territorial sovereignty, but granted leave to file an amended complaint. When plaintiffs filed an amended complaint, the district court dismissed it as barred by the law of the case doctrine. We concluded that it was an error to apply the law of case doctrine on a motion to dismiss an amended complaint. On the merits, we conclude that the plaintiffs have stated First Amendment claims upon which relief can be granted. So they're not saying whether the plaintiffs will win, but they say that you actually have stated a case. You have a good case, or you have a case that you've made a claim. You say that you had a right to film there. It's a reasonable claim, and we can actually grant relief. It's a ripe case. We could do it. We vacate the judgment and remand for further proceedings. Factual and procedural background. I'm not going to read the stuff about the law of case doctrine. It is not necessary or relevant, really, to First Amendment analysis. It's more of a procedural kind of issue. Factual and procedural background. Plaintiff's suit stems from two separate incidents because the district court dismissed the plaintiff's suit on the government's motion to dismiss. For purposes of this appeal, we accept as true plaintiff's allegations in the amended complaint. So they are on appeal. The party that's bringing the appeal, they're taking everything that the plaintiff said as true to see if there was good cause by the lower court to dismiss it. Because a dismissal, a motion to dismiss, means that even if you accept everything that the plaintiff said is true, like if the defendants do a motion to dismiss, even if what the court is looking at is even if everything the plaintiff said is true, there's still not something that we can give them relief on. And so because the district court looked at it and said, yep, there's nothing we can give him relief on. Now the Court of Appeals is also going to accept all of the plaintiff's allegations as true. Nothing has been tried. So don't take any of the things that they're saying in here as being proven. Okay? But for the purposes of this appeal, these are the facts that the Court of Appeals is basing their decision on. The incidents. At Calexico West, Ray Askins is a U.S. citizen concerned with the environmental health hazards in Imperial County and near the U.S.-Mexico border. He has a special interest in the effect of emissions from vehicles idling in the inspection areas at the ports of entry on California air quality. In April of 2012, Askins sought to photograph the secondary vehicle inspection area of the Calexico West port of entry in connection with a conference presentation he was preparing on the health impacts of border crossings. When Askins called CBP to request permission, he was told by an officer that this would be inconvenient, but his request was neither approved nor denied. The next morning, he informed the officer by voicemail that he would photograph the exit of the secondary inspection area from the street outside instead. The exit of the Calexico West secondary inspection area and port of entry building exterior are visible from the streets on or near the port of entry and from the Gennaro Taco Monroy Memorial International Border Friendship Park, a small park with a very large name. On the afternoon of April 19th, Askins stood at the intersection of the 1st Street and Paulin Avenue on the U.S. side of the border, near the shoulder of the streets, and immediately in front of the park. He was approximately 50 to 100 feet from the exit of the secondary inspection area, and he had not crossed the border or otherwise passed through border security to reach his location. Standing in the street, Askins took 3 or 4 photographs of the exit of the secondary inspection area. Multiple CBP officers approached Askins on the street to demand he delete the photographs he had taken. When Askins refused, the officers threatened to smash his camera, then searched and handcuffed him, confiscated his property, and detained him inside of a secondary inspection area building. Askins was released after approximately 25 to 35 minutes, and his property was returned, at which time he discovered that CBP had deleted all but one of his photographs of the exit of the secondary inspection area. Askins alleges that he wishes to photograph matters and events exposed to public view from outdoor and exterior areas of the Calexico Port of Entry and in the area immediately surrounding the Calexico Port of Entry building. Specifically, vehicular traffic and CBP officers engaged in the public discharge of their duties in order to document air and other environmental pollution as well as human rights abuses. He claims that he now refrains from doing so. What he's saying is it's chilling his speech, so he's trying to get an injunction on it. He claims that he now refrains from doing so in light of the CBP policies and the past enforcement of those policies against him. Number 2, San Ysidro. Christian Ramirez is a U.S. citizen and policy advocate who works on human rights issues in border communities. On June 20, 2010, Ramirez and his wife visited his father in Mexico, parking on the U.S. side of the border and crossing through the San Ysidro port of entry pedestrian entrance. They crossed back into the U.S. later that same day. After they had passed through inspection, the Ramirezes crossed a pedestrian bridge over Interstate 5 to return to their vehicle. While on the bridge, Ramirez observed male CBP officers at a security checkpoint below inspecting and patting down only female travelers. Concerned that the officers might be acting inappropriately, Ramirez observed the checkpoint from the bridge for 10 to 15 minutes and took approximately 10 photographs with his cell phone camera. Ramirez and his wife were approached by men who appeared to be private security officers. The men ordered them to stop taking photographs. The officers also demanded their identification documents, which Ramirez refused to provide as they had already passed through border inspection. The officers radioed for backup as Ramirez and his wife walked away, and at the bottom of the bridge, Ramirez was met by 5 to 7 CBP officers. The CBP officers questioned Ramirez, and without Ramirez's consent, a CBP officer confiscated Ramirez's cell phone and deleted all the photographs Ramirez had taken from the bridge. A U.S. Immigration and Customs Enforcement officer confiscated the Ramirez's passports and walked away, leaving Ramirez surrounded by the CBP officers. After 10 to 15 minutes, their documents were returned to them, and the Ramirez's were allowed to leave. The pedestrian bridge from which Ramirez took the photographs has since been replaced. The new bridge runs east to west, passing over Interstate 5 to connect the San Ysidro Boulevard Transit Plaza and Camiones Way, both on the U.S. side of the border. Plaintiffs allege that the bridge is open to and used by the public to cross over Interstate 5, and that members of the public can and do frequently cross the bridge without crossing the border or entering or exit any port of entry building. The outdoor vehicle inspection areas in which CBP conducts primary and secondary inspections at the San Ysidro port of entry are visible from the new bridge. Ramirez alleges that he wishes to photograph matters exposed to public view, including CBP officers engaged in the public discharge of their duties, from the new pedestrian bridge, the San Ysidro Boulevard Transit Plaza, and a footpath leading from the Transit Plaza to the border. U.S. government signs posted at these locations prohibit any form of photography. Ramirez claims that he now refrains from documenting matters and events visible from those locations in light of the CBP policies and the past enforcement of those policies against him. So the initial complaint was dismissed. Then they filed an amended complaint where they dropped all the... I'll read it. Why not? The initial complaint. Plaintiffs filed suit in October 2012 against the Department of Homeland Security, named officials of CBP, and 50 unnamed CBP officers. Plaintiffs claimed that CBP's policies and practices violated their First and Fourth Amendment rights and sought declaratory and injunctive relief, damages, and costs and attorney's fees. The government moved to dismiss under Rule 12b-6, that's failure to state a claim upon which relief can be granted, and brought the court's attention to 2 CBP policies. CBP Directive number 5410-01B from March 18th of 2009, they call that one the directive, a national policy defining guidelines relating to the disclosure of official CBP information to accredited news organizations, mass media, published professional journals, and stakeholder groups, and CBP's ground rules for news media representatives when visiting Southern California ports of entry, and they're going to call that the ground rules from here on out. The government argued that under these policies, any individual seeking to film or take photographs at ports of entry is required to obtain prior authorization. The district court held that the plaintiffs had sufficiently alleged the policies were content-based restrictions, which is good, on speech in a public forum, which is also good, triggering strict scrutiny. Normally, plaintiffs win on a 1983 lawsuit where there's strict scrutiny, normally. But the court decided that the policies survive strict scrutiny because they serve perhaps the most compelling government interest. Now, remember, the test for strict scrutiny is there has to be a compelling government interest, and it has to be the least restrictive option to meet that compelling government interest. And it has to be viewpoint neutral. So if it's a content-based restriction, it has to be viewpoint neutral, it has to serve a compelling government interest, and it has to be the least restrictive alternative. So we have a compelling government interest. Great. Protecting the territorial integrity of the United States. Okay. And there were no less restrictive alternatives. Well, that's a conclusory statement. The district court granted the motion to dismiss with leave to amend with respect to the constitutionality of the CBP photography policy. So then they amended the complaint. Plaintiffs filed an amended complaint in 2015 against the U.S. Department of Homeland Security, the Commissioner of the U.S. Customs and Border Protection, and the directors of the Calexico West and San Ysidro ports of entry. Plaintiffs submitted any claims based on the Fourth Amendment, dropped their claims for damages and did not sue the unnamed CBP officers. Plaintiffs also formally challenged the CBP policies identified by the government under the First Amendment. First, they challenged the policies on their face as prior restraints. Second, they challenged the policies as unreasonable as applied to them. The policies, which we will refer to as the directive and the ground rules, require members of the media to obtain advance permission to document events at ports of entry. Under the directive, CBP shall cooperate with accredited local, national, and foreign news organizations without favoritism. Hey, look, it's accredited. In the dissemination of official information while not compromising the DHS CBP mission. Section 6.2 provides procedures for media requests to photograph suspects and states that decisions to allow any photographing, videotaping, or filming by the media at CBP facilities shall be made in consultation with the appropriate public affairs specialist and with the concurrence and control of the appropriate CBP supervisor. It also provides that photographing of suspects, detainees by news organizations in public places or in transit is neither encouraged nor discouraged, and instructs CBP that when news organizations arrive at the scene of an enforcement action in progress without prior CBP knowledge, CBP personnel shall not interfere with photographing suspects in public places or in transport. The directive prohibits the detention of persons or media and or the detention of recording equipment, film, or notes unless the owner or operator of such material has violated federal law, unlawfully breached the security of a CBP facility, or has endangered the safety of CBP personnel. The ground rules, which apply to ports of entry involved here, are directed towards accredited news media representatives, again accredited, and are motivated by concerns for the privacy of the traveling public, integrity of law enforcement and investigative activities, and safety of visiting media representatives and the public. They require members of the press who desire to film, conduct interviews, or engage in any other media activity to clear their visit in advance with appropriate CBP officials. Under the ground rules, reporters who do not have such clearance may be denied access to port property, and photographers and camera crews must be escorted by a designated officer at all times while on port property without exception. The ground rules prohibit photography in non-public spaces such as the pat-down room and holding cells and merchandise storage areas, close-up photographs of port computer screens, and recognizable photographs of CBP officers without their permission for reasons of officer safety. Plaintiffs allege that CBP interprets and enforces these policies as a total ban on all photography by any person from any area within a port of entry without prior authorization from CBP. Plaintiffs do not allege CBP's restrictions on photography within CBP facilities, such as buildings and inspection areas. Rather, plaintiffs allege that there are large swaths of property owned or leased by CBP that are public streets and sidewalks, and that these constitute traditional public fora, and that CBP enforces its no photography policies within these areas in violation of the First Amendment. The government moved to dismiss the amended complaint for failure to state a claim. The district court held that it was precluded by the law of case doctrine from revisiting its prior order because plaintiffs brought the identical issue but failed to identify any clear error, intervening change in law, new evidence, changed circumstances, or manifest injustice resulting from previous decision. The law of the case barred plaintiffs' claims. The district court entered judgment for the government. Plaintiffs timely appealed. So I'm not going to go over the law of case doctrine. It just means that if a law is decided one way in a lower court, it stays decided that way in any courts of appeals or higher courts, unless it is basically clear error or something like that. It doesn't really matter for us. And there you go. There's Musacchio v. U.S., etc., U.S. v. Cuddy. Anyway, I'll link this so you can go over it and figure it out for yourself if you're really interested in it. But what we're here for, kids, is the First Amendment. In their amended complaint, plaintiffs claim that CBP's policies impose unconstitutional restriction on their First Amendment right to photograph and record CBP officers engaged in public discharge of their official duties. They contend that the policies impose a prior restraint and prevent the documentation of civil and human rights abuses, including the excessive use of force and racial or religious profiling at the border. They do not seek unrestricted access to all areas of ports of entry or unlimited photography privileges, but rather assert a right to photograph only those matters that are exposed to public view from exterior or outdoor areas of the Calexico and San Ysidro ports of entry. Plaintiffs have alleged that these areas, even if leased or owned by CBP, are public streets and sidewalks that must be considered public fora. So they're looking at streets and sidewalks. I know that in this video, James, the unfortunate sovereign citizen, thinks that the court is talking about. The court in the hearing was asking about, is there any indication that it's private or that it's owned by CBP and bounded and something like that. And James is thinking in his head that, it means like secured areas. Only secured areas can they restrict your filming, and that's not it. If you remember back to Grace, U.S. v. Grace, the U.S. Supreme Court invalidated a law that prevented certain forms of political speech on Supreme Court grounds because there were sidewalks that were bordering the street, and they looked like every other sidewalk. And that restriction on that political speech extended to those sidewalks. And because those sidewalks were indistinguishable from any other sidewalk anywhere else in the country that would be a traditional public forum that a citizen would assume, because of the look of it, because of its use and everything, that it is a traditional public forum like every other sidewalk, that statute was invalid. It was overbroad. It reached to areas that it couldn't reach. Now, if there was something demarking those sidewalks, like if signs were put up, perhaps, in Matsumishi, there were signs placed up in the area. Now, again, that one's settled, so whatever. But if there were signs up there, and if the government was enforcing the no photography policy, then maybe it would be different. And you also have to remember that Vandenberg, Appel v. Vandenberg, and Greer v. Spock, or Spock v. Greer, I forget which it is. Streets, even if they look like every other street, on a military base, are still non-public forums. So keep that in mind. So James is wrong, and that's the danger of somebody who doesn't understand what they're looking at trying to interpret it and teach you about it. He has no idea what he's talking about, and that's the problem. He can't really comprehend it. But anyway, we will continue. The First Amendment protects the right to photograph and record matters of public interest. This includes the right to record law enforcement officers engaged in the exercise of their official duties in public spaces. I'm skipping over all the bracketed stuff where it's just kind of giving the language of it, and you can always go back and read it for yourself. Whether a place is public depends on the nature of the location. The government's ability to regulate speech in a traditional public forum, such as a street, sidewalk, or park, is sharply circumscribed. Content-based restrictions on speech are subject to strict scrutiny and may only be upheld if they are the least restrictive means available to further a compelling government interest. Reasonable, content-neutral, time, place, or manner restrictions, on the other hand, are subject to an intermediate level of scrutiny. They are permitted in public fora so long as they are narrowly tailored to serve a significant government interest, leave open ample alternative channels for communication of the information, and do not delegate overly broad licensing discretion to a government official. In contrast, restrictions on speech in a non-public forum must only be reasonable in light of the purpose served by the forum and viewpoint neutral. The district court assumed, for purposes of deciding the government's first motion to dismiss, that the areas adjacent to Calexico West and San Ysidro were public fora and that the CBP's restrictions were content-based. That meant that the government had the burden of demonstrating that its restrictions on speech were the least restrictive means necessary to serve a compelling government interest. The district court found that the CBP policy survived strict scrutiny because of the extremely compelling interest of border security and the government's general interest in protecting the United States territorial sovereignty. To this, the government adds that the CBP policies serve compelling government interests in protecting CBP's law enforcement techniques and the integrity of ongoing investigations, protecting the privacy of travelers, suspects, and sensitive digital information, ensuring the safe and efficient operation of the ports of entry, and protecting against terrorist attacks. In conclusory fashion, the district court held that the policies were the least restrictive means of serving these interests. So, we don't know that they were the least restrictive means, and most likely they weren't. These conclusions are too thin to justify judgment for the government on a motion to dismiss. When the government restricts speech, the government bears the burden of proving the constitutionality of its actions. It is rare that a regulation restricting speech because of its contents will ever be permissible. Without question, protecting our territorial integrity is a compelling interest that could justify reasonable restrictions on speech activities at ports of entry. But the devil lies in the details. Even at the border, we have rejected an anything-goes approach. It is the government's burden to prove that these specific restrictions are the least restrictive means available to further its compelling interest. They cannot do so through general assertions of national security, particularly where plaintiffs have alleged that CBP is restricting First Amendment activities in traditional public fora such as streets and sidewalks. You may notice a theme here. They are still talking about streets and sidewalks, Mr. Freeman. They're not talking about enclosed areas. They're saying streets and sidewalks are traditional public forums. Moreover, in determining whether a location is properly categorized as a public forum involves largely factual questions. We have adopted a fact-intensive three-factor test to determine whether a location is a public forum in the first instance. We consider 1, the actual use and purposes of the property, particularly its status as a public thoroughfare and availability of free public access to the area. Now, there's two things here. So you're going to look at free public access, Mr. Freeman, and you're going to say, well, that means like if people can go there. But it's a three-factor test, and the first factor has its status as a public thoroughfare and, not or, and ability of free public access to the area. The second of the three-factor test prongs is the area's physical characteristics, including its location and the existence of clear boundaries delimiting the area. And 3, traditional or historic use of both the property in question and other similar properties. How these factors apply here cannot be answered without development of the record and a separate consideration of the Calexico West and San Ysidro ports of entry. At Calexico West, Askins took photographs from the shoulder of 2 streets and will continue to photograph the exterior areas of the port of entry from those streets, the nearby park, and other public outdoor locations. It appears from the one photograph that we have in the record that the streets on which Askins stood are indistinguishable from other Calexico City streets, and the amended complaint indicates there are no signs or other indicators marking the port of entry boundaries. So that looks a lot like the US v. Grace test, and there you go. Furthermore, the Gennaro Teco Monroy Park abuts those streets, and the government concedes that the park is not part of the port of entry, which means that Askins presumably could have taken the same photographs of Calexico West had he taken only a couple of steps back from the street into the park. Public streets and parks are the archetype of a traditional public forum. When a property is used for open public access or as a public thoroughfare, we need not expressly consider the compatibility of expressive activity because these uses are inherently compatible with such activity. Even if we were to assume these areas are part of the port of entry, we would need to know much more about the port of entry's boundaries and the public's access to and use of Calexico West streets and sidewalks before we could decide the relative importance of banning photography from those streets and sidewalks. San Ysidro presents a different set of circumstances. Ramirez took photographs of the San Ysidro port of entry from a pedestrian bridge and wishes to take photographs from the new pedestrian bridge, a transit plaza, and the adjacent sidewalk. Unlike the streets adjacent to the Calexico West port of entry, we are told there are signs prohibiting photography on the pedestrian bridge overlooking the San Ysidro port of entry. The government compares ports of entry to military bases, airport terminals, and interstate rest areas, portions of which have been held to be non-public fora. But the boundaries of the San Ysidro port of entry are neither established by the record, which means that they aren't established by this record in this proceeding. I'm sure they have records of what those boundaries are, nor a matter of which we can take judicial notice. Judicial notice just means that they don't have to. Like, you could take judicial notice of the date because you know what the date is. The judge doesn't have. You don't have to establish what date that day is. Like, okay, today is December 13th of 2018. The court can take judicial notice of it. The court can take judicial notice that Mexico is south of the U.S. You don't have to bring an expert in there or somebody to testify about that. A judge knows what a map looks like, and he'd be like, yeah, Mexico south of the U.S. Congratulations. Have a great day. And even accepting that the San Ysidro port of entry facilities are a non-public forum, the public's access to and use of the transit plaza, sidewalks, and other outdoor areas is critical to determine whether they retain their public fora status. We do not mean to suggest that all or even any areas within a port of entry are necessarily public fora, or that allowing the public to transit through a port of entry for the purpose of crossing the border creates a public forum. We decide today only that the plaintiffs have adequately pleaded their claims and that further factual development is required before the district court can determine what restrictions, if any, the government may impose in these public outdoors areas. For the foregoing reasons, we vacate the district court's dismissal of the plaintiff's first amended complaint and remand for further proceedings. Costs shall be taxed against defendants' appellees. So now that I've gone through this, and now that maybe you have a bit better understanding than what James Freeman was trying to give you by playing the hearing and not giving you the actual conclusions from the hearing, let's see if he actually did. Because I didn't actually watch this far. And no, he did not. Congratulations, James Freeman, you fail again. Now we have the conclusions. Now we know what the government, or what the judges were looking at. Now we know that what the government has to prove. The government is going to have to prove that the streets are somehow either non-public forums, which will reduce the burden of proof and shift it over to the plaintiffs, or they're going to have to prove that their compelling government interest, we know that exists, but they're going to have to prove that not allowing people to film from those areas is the least restrictive way of protecting those compelling government interests, as opposed to, I don't know, putting up a cinder block wall, or a putting, like, in their chain link fence, you know how they can put those privacy screens up along the fence. Instead of doing that, you know, so the government's going to have a lot harder time proving their case. As far as the other one, as far as the footpass and overpass, the government's going to have to prove, again, the government wants to prove it's a non-public forum and that it's reasonable and viewpoint neutral to prevent people from filming there. Which, is it reasonable? I don't know. I don't know. I don't know. Anyway, I think a court will probably find that it is reasonable because they're able to film down into the port of entry operations areas from the bridge. And they don't have to do it by the least restrictive means necessary. But what the plaintiffs are going to want to do is they're going to want to prove that it is actually a traditional public forum, which is going to set the burden much higher for the government to restrict filming there. None of this has anything to do with filming in a court. I still challenge James Freeman. If he thinks that filming in a courtroom is a First Amendment right that he has, he can march his happy ginger butt to the U.S. Supreme Court and try to walk into that courtroom with a camera and film it. That will prove it. That will put this baby to bed. If you can film with your cell phone, if you could even get your cell phone into the Supreme Court, I'd be surprised. But if you could film with your cell phone in the U.S. Supreme Court, then you have met your burden of proof, and I will concede to you, you balding ginger wonder, that I am wrong and you're right. But until then, there is nothing to suggest that you have any grasp of the law. You are still wrong, and your mistaken belief that somehow this hearing supports your silly, misguided viewpoints, I think you should feel ashamed of yourself, but you're not. You don't know enough to know how badly you blunder. Thanks for watching, and have a great day.